May it please my lords, may I start by apologizing for the very poor audio and voice that was disseminated at the last time I was required to speak on this subject. What has happened was I'd gone out to get headphones that I thought were the most reliable. I eventually got feedback that most of my speak was not audible, and that was clear from the question and answers that was, that formed the subject of discussion after my speak. Because I'm desperate to ensure that we disseminate information and share my experience, because I was involved in creating this entire structure, I gave my word to the organizers that I'll do a podcast where I'll speak to my slides. And I do apologize for those who heard it clearly, but I want to discuss some peculiar provisions of this act. I think this is one of the most important acts that was passed in 2017, and this can revolutionize the access to credit by individuals, micro, small, and medium enterprises. Let me start like this. What is the objective of the act? The act sought to do two things. It created a regulatory framework for access to credit. It also created a national collateral registry where we can house collateral, movable collateral that has been offered in return for credits. It's a collateral that secures a payment obligation or some other obligation. The point is this: in Africa, and in Nigeria in particular, 89% of the population will usually not have landed property. Ironically, if you do want credits and you go to any of the institutions, financial institutions, you will be required to offer land as collateral for that credit. What this act does is to permit you to offer movable assets as collateral for credit. But there are complications, of course, when you take security over a movable asset. The short lifespan of an asset and the fact that it can easily be dissipated, it can easily be destroyed in itself creates complications. So, let me start by sharing what I consider to be security in the first place. What is security? It is simply offering some sort of assets predicated on a contingent failure. So that asset will only be realized if one is unable to meet his payment obligation. I'm going to focus on debts. I'm going to focus on credits. In the first place, the two things that needs to be established when we're talking about collateral. In every transaction of a collateral transaction, there are two separate contracts that we're talking about. There is usually the loan contracts, the loan obligation, the credits, or some other obligation. It may be a service obligation. And the party who is offering credits is interested in ensuring that where there is a failure, he can gain access to the collateral to satisfy or discharge the indebtedness. So you have two separate transactions: the loan obligation and the secured transaction in itself. In other words, the security that has been offered for the discharge of their debts. The second point that I'd like to make is that in order for one to appreciate the concept, one needs to realize that the party who is offering the security must establish ownership of that property. So if we were dealing with land, for example, you can only offer the land as security if you own some proprietary interest in the land. It is the same concept as it relates to movable assets. So, two things that I think is fundamental before one moves on. One is that there are two separate transactions in every secured transaction. One is obviously dependent on the other, not parasitic on it, but dependent. In other words, if the debt is discharged, then the security must be released, so to speak. And if the debt continues to exist, then there is obviously a contingent liability which will be satisfied by the sale of that asset. Second point, as I said earlier, is that the party who is offering the security must establish some proprietary interest over the assets. And I think that's very important. I did say there were some peculiarities when we're dealing with movable assets. And that is, firstly, it has a short lifespan and it could easily evaporate and is subject to transfer and therefore fraud. In other words, if I create an asset, if I create a charge over an asset, I could easily sell the asset or dissipate the assets. So creditors are usually concerned about taking security over movable assets. This act has come to provide elements or criteria that reduces the risk of those the risk that I identified that would enable people who offer security simply sell it. So, because the party who is offering the assets as a collateral must establish some proprietary interest, it is important to distinguish the different types of property interest that exist in relation to property. It is important to distinguish the different types of ownership interest that exist in relation to property. And I will identify 4 types of property for these purposes, and I think it's very important. First, we have chattels, and that's easy. We're talking about consumables. We're talking about personal consumables. This will include things like television, radios, cars, barbing machine, a vulcanizer's machine, anything that can move around in a property. As long as you can demonstrate ownership over that property, you should be able to create security, collateral. You should be able to offer that asset as a collateral. The second type of property that is important is one that we're familiar with, which is land. This particular act excludes land, and that's why it's an act that deals with movable assets. When we talk about land and we talk about collateral and the registration of such interest, we're talking about the Land Use Act, and we're talking about the Land Registry, and we're talking about the Corporate Affairs Commission. I will come back later to demonstrate the distinction between interests that are registered at the Corporate Affairs Commission as opposed to interests that are registered at the collateral registry. But land is excluded. This act does not apply when you are offering land. However, it applies to interests that are derived from land. In other words, account receivables, rentals from land. So although the act does not apply to land, if I rent my property out and I'm expecting a rent to be paid, I'm expecting receivables, and I document it in a book, that becomes an account, and I'm expecting a receivable, becomes an account receivable on my book. That is property over which interest, over which a charge can be taken, over which the creditor can take as collateral. The next property that we'll talk about are intangible properties. And there are 2 types. There's documentary intangible, and then there's pure intangible. Documentary intangibles relate to documents that represents a right to payments, an IOU. Every document that requires the recipient of that document or the person to whom it is directed to make payments at a future date is a negotiable instrument. Or it's an instrument, it may not be negotiable. Whether or not it's negotiable will depend on the particular act. There's a process by which you make an instrument negotiable. So a simple IOU is a documentary intangible because it locks a payment obligation and is directed to a particular recipient. Whether or not it's an assignable one will depend on whether or not it complies with the law of assignments, which is an act of the Law of Property Act of 1925. So you have documentary intangibles. And then you have other pure intangibles. Pure intangibles, I could distinguish between two types of pure intangibles. There is what I call, or what is called, the shows in action. That is the right to claim a particular money or a debt. Those types of assets are assets which, as I said earlier, are pure intangibles, and you can only realize them by actually going to court. So it's a shows in action. Then you have the other type of intangible, which is, I mean, you can say that it's incorporated, it's inclusive in a shows in action. Those are account receivables. And as I said earlier on, an account receivable, as the name implies, is simply an account that shows or demonstrates that you are entitled to some receivable. So let me use a practical example. There's a lady who sells a mama put in Broad Street, and then there's Wale, Tunde, and Kende who work in First Bank or Barclays Bank or whatever bank is situated in Broad Street, and they are accustomed to eating every day, and they establish a relationship with mama puts, and they only pay for what they consume at the end of the month. So she offers credit, so to speak, and her little daughter who lives with her documents what is being taken on a daily basis, and Wale, Kende, Tunde, they would all pay at the end of the month. That book where it is documented shows who is indebted to mama puts. The fact that Wale, Tunde, and Kende owe mama puts is a representation of the asset of mama put, albeit that is an asset that she will realize at the end of the month. But the economics and lawyers treat it as an asset. Mama put needs to continue to do her business, and she needs money. So she goes to a simple financial institution. Usually there are these men who carry a little bell around saying they can give credit. Usually it's quite expensive. She then offers that book and say, look, if I don't pay you back, you can actually go and meet Wale, Kende, and Tunde to realize my debt by collecting it from them. What I've just described is what is extremely common in Lagos Island. Before now, all this was informal. So I've identified three characteristics there. First of all, there's a book debt because she's recorded it. There's an account debtor. That is Wale, Kende, and Taiwo. And then there is actually the mama put herself, who is the borrower. And then, of course, you have the gentleman who's going around offering the credit, who is the lender. So, the lender takes a charge, so to speak, over the asset of mama put. That asset being an account receivable, which is an obligation by the account debtor to meet mama put's to meet his obligation at the end of that month. What the Act now does, and what the collateral registry does, is to register that transaction by simple credit, a simple security agreement, which will state that there is a loan which has been taken by Mama Put. The financial institution, for the purposes of this discussion, let's say any of the banks, GTB, usually would not be a bank, it would be a small microfinance bank who would have given the debt to Mama Put. The microfinance bank can apply to the collateral registry to register that simple security agreement. Once it is registered, anyone can go there and will realize that the asset of Mama Put is subject to a charge. And if Mama Put doesn't meet her obligation, the financial institution, being a microfinance bank, can go directly to the account holder, the account debtor, being Wale, Kendi, or Taiwo. That simple relationship before now was done informally. Now it is formalized, and because you have a place where you can register that interest, many more institutions are ready to give credit. So I've identified 3 or 4 properties, and it's key to identify these properties. Chartels, which comes under the regime. Account receivables relating to land, which comes under it, land is excluded. Shows in action, which is a right to claim a particular debt. And then you have intangible documentary, and you have pure intangibles. Both are also covered under the Act. If you take security over any of these assets, you'll be required to register it. Of course, the purpose of registration is to ensure that if there is liquidation, you can get your money back by selling the assets. But even in the absence of liquidation, if there is a failure of that debt, you can actually realize the security and discharge the debt obligation. So it is important that we classify the different types of properties and understand those which are subject to the Movable Transactions Act. Let me explain further the different types of intangible property that you will normally encounter. I've talked about a few, but let me classify them like this. The first one that will be very common, and when I say common, I mean that individuals, micro, small and medium enterprises will normally not have any other asset to offer as collateral. What most of them will have will be account receivables. So you have the Mama Put, the example I gave. You have somebody who is cutting people's hair, it's just a barber. You have people who are going around having only an intellectual property, good footballers, good sculpturists. These are young persons within the country who would not have any other asset other than their intellectual property. All that property can now form the basis of collateral, and they can be registered under the Act. So I talked about account receivables, and I explained that before now. It is simply an account expecting receivables and documented in a book. If it's a large institution, we say it is documented in its P&L, profit and loss accounts, its balance sheets. If it's a small enterprise, or if it's an individual, it will usually be documented in a small notebook, and that's sufficient. As I did say, the lady who's selling food will have a little daughter stay by her who will document those who are indebted to her in a small book. That book becomes your account receivable, and those who are expected to pay money are the account debtors. That asset, as I did say earlier on, is an asset that is that can be a subject of collateral and over which a charge can be taken. It's a registrable interest, and the collateral registry will be required to register that interest. Never before have you had any structure that enables that kind of registration. I will talk about what is similar, which is a debenture, under CAMA. I'll talk about it later when I come to demarcate the difference, when I come to talk about the demarcation between CAMA and the Secured Transactions Act. The other type of property over which interest could be taken is what I talked about before, a shows in action. What is a shows in action? It is simply a right to claim money, a debt, a right to claim something. That is the only way you can realize that asset. So, whereas if we were talking about land, the antithesis of a shows in action is self-help. You go there and take physical possession. But with intangibles, you cannot take physical possession because an intangible is not subject to physical possession. So if you think about it, if a third party is indebted to me, I can't go and just realize the debt because he has his money in a bank. I would have to bring an action. So a shows in action relates to those actions which you can only realize by bringing an action in court. It's a broad right. It relates to contractual rights. It relates to any rights over which its actualization can only be secured by taking legal action. A negotiable instrument. I talked about it briefly before now. An instrument that incorporates a debt obligation, an IOU. Whether or not it's negotiable will depend on whether or not it satisfies the Law of Property Act 1925. And simply what that act says is that it must be in writing, you must give notice to the debtor, and it must be transferable as regards the entirety of its interest, not part of its interest. So it's like a check or an IOU. If an IOU is issued in my favor, I hold it on a particular day, I go to the party who's issued it to pay me. But I can also transfer that IOU if I satisfy the conditions of the Law of Assignments or the Law of Property Acts. And I can take it to a third party who will then go to the recipient of that or the recipient of that document to collect the money on the day that it materializes, because its payment is a payment obligation in the future. Also, another interest of property that could be subject of collateral and registered that the charge will be registered against it, contractual rights. And that's easy. If I sign a contract to purchase a car and I've paid for that car, the manufacturers are under obligation, a reciprocal obligation, to turn that car over to me. Now, it might be it might be at a future date. I can transfer that right. I can enforce that right. That right is a right that is considered to be property over which a charge could be taken. Finally, there are book debts. A book debt is similar or identical to an account receivable. It's a book and there's a debt. The difference is that we use the term book debt when the company or when the partnership is insolvent or when the individual is bankrupt. So you keep an account, and let's use the same example, the analogy I had offered earlier on, of the mama puts who records those who are indebted to her, and then all of a sudden mama put goes bankrupt. When the liquidator comes in, that document, that book that records the account receivable is treated as a book debt, and the liquidator then classifies how the obligations will be satisfied and who gets what first. So when the liquidator comes in, when the mama put becomes bankrupt, if it's a small company, when it becomes insolvent, the account receivable is referred to as a book debt. These are the type of properties over which a charge is taken. My lords will agree with me that these are not normal properties that we deal with every day in terms of properties that form the subject of litigation, but these are the type of properties which a majority of Nigerians are dealing with every day. It has to be classified, and we have to understand the nature of the charge that can be taken over it so that it is subject to registration, because it leads to access to finance. Recall that I did say that the objective of the Act is to encourage responsible lending to small, micro, small, medium enterprises. Let me now deal with something slightly different, but related, which is the legal framework that exists at the collateral registry. How do you register this? This is simple. How do you register an interest? The grantor is the person who's offering the security. It can either be the borrower or a third party. And the credit provider, who is the lender, once they enter into an agreement, the collateral registry is informed, usually electronically, you don't need to go there, that security has been taken over a property. Now, if we're dealing with a manufacturing asset, this is even more interesting. All authentic manufacturing assets have a universal number. Maybe a camera, it may be a vulcanizer's machine, and that universal number is what is registered in the collateral registry, and a certificate is then issued, and then you know that you've obtained effective registration. The point about the universal number is anyone who wants to know the location of that particular assets, in other words, what's been done with that asset, all you need to do is to conduct a search. Once you are registered, you have priority over anybody else who deals with that property, not taking cognizance of that registration. Let me compare that with the Corporate Affairs Commission. I did say I would do a comparison, but I can talk about the Corporate Affairs Commission. How do you register it? You complete your debenture. And what's a debenture? It's simply taking a charge over all the assets of the company. That is all you can register at the Corporate Affairs Commission. Remember that at the Corporate Affairs Commission, you only deal with assets that belong to a company, whereas at the STIMA, you deal with assets that belong to individuals, small and medium-sized enterprises that are not companies. So an individual an individual's asset can be subject to registration at STIMA, at the collateral registry, but not so with the company's house. With the company's house, you must have a company registered. So you can see why the National Collateral Registry will be far more useful to many more Nigerians, because most Nigerians don't have companies. They just operate a bilateral relationship with other individuals. There is another act that has a reference to this particular to Movable Assets Act, which is the Equipment Leasing Act of 2015. But please bear in mind that that act has no reference whatsoever, no bearing on the Movable Assets Act. Equipment leasing is not a charge, or maybe I should put it differently. With leasing, there is no collateral that is offered, because the lessor keeps title and leases out the equipment. So this must not be confused with collateral. And if you're going to register, if there's going to be any register, it's under the Leasing Act. I'm not sure there's a national registry like the collateral registry, but it's important to know that leasing has no business with it. However, the receivables that derive from a leasing could be subject of a charge. That's property, as I said earlier on, that's subject of a charge. Now, let me go on to deal with some of the innovations that have been created by these acts. The first one that I like to deal with is the question of an asset, if an asset has been disposed of by sale, because remember that these assets are within the possession of the grantor, of the borrower, so he can sell it. What happens? This act is innovative. The proceeds of sale from that particular asset are also charged as a result. In other words, the charge travels. In common law, this is called tracing, but the principle of tracing is a very complicated one under common law. this act elevates that right such that it is expressly stipulated that where the asset is sold, the charge travels with that sale and attaches to the process of sale. So where there's money in a bank, you can actually go and charge that money in the bank so that the debt is discharged. I think that is very good for this particular act. Not only will creditors get comforts from this, but it also effectively deals with the particularity of a movable asset. The second innovation that I'd like to talk about is what is known as, in common law, the Romampa clause. Now, if an asset, and let's say we take a cow, you can actually take a charge over a cow, and people will ask, how do you do that? Because the act requires you to specify the asset and give particulars. In other words, the name of the assets, the universal number, the description of the assets. So how do you take a charge over a cow? Simple. You actually put a chip in the cow's ear, and that chip identifies that cow. But recall that the cow remains in the possession of the borrower, so he could slaughter the cow. And if he slaughters the cow, it becomes suya. What the act stipulates is that the charge is actually translated into the further produce that results from the change of character. So the borrower has a charge in the suya. If we take fish, for example, the borrower has a charge in the sardine that has been created. So one can see the extent of the protection that is given to the creditor by these acts. Of course, there can be complications when there's insolvency or liquidation, where there are many creditors who have given credits using that same collateral. The beauty about this is that in the act, registration gives priority. I'll talk about priority briefly when I come there, but let me just digress very quickly. The priority is such that once you register, you have priority. In other words, first registration. This is not the same at the corporate house. I know that a lot of lawyers often confuse this and think that registration gives you priority. No. At the corporate house, it is the creation, or let me say at the common law, it is the creation of the collateral interests that gives priority. Of course, registration is key, because where there is no registration, the subsequent creditor can argue that he had no knowledge of the earlier created charge. But by common law, it is the charge that is created first, the interest that is created first, that gets priority. Whereas at the National Collateral Registry, is regardless of when the interest is created, is registration that determines priority. Let me deal with perfection, or let me deal with the comparison between CAMA and STIMA for shorts. The first distinction is that the creditor can sell the assets, and this is a sensitive issue, can sell the assets which has been offered as collateral without reverting to court. There is no opportunity for a collateral offered under the Companies Act to be sold without reference to court. I know that this proposition will create some discomfort among the judges, but there's nothing to be worried about, because one needs to think about it very deeply. The assets that are being used, these movable assets, have two characteristics that require that the asset be sold without reference to the court. First of all, they have a short lifespan, and secondly, they are assets that can evaporate within a very short while. There are quite a few of these assets are perishable assets. In fact, what the Act provides, or what it stipulates, is that where it's a perishable asset, you may be able to sell the assets without reference to the borrower. Now, when you think about it deeply, or when one thinks about it deeply, the assets that are being used as collateral and subject to registration at the company's house are more static. And when you take a charge, the charge does not give you a right to sell. It gives you a right to appoint a receiver. One fundamental distinction between CAMA and STIMA is that whereas you can take a charge over a specific movable asset and register it at the National Collateral Registry, there is no opportunity for such registration in CAMA. The best you can get is to get a floating charge over the entirety of the assets, and so it doesn't crystallize until there's a failure. Whereas with STIMA, it's more or less crystallizes once you can identify the assets, you mention the number, you describe it effectively, you have a specific asset that can discharge your obligation when there's a failure on the part of the borrower. So the one main distinction is that whereas with the Corporate Affairs Commission, the Companies House, you are not permitted to sell the assets without reference to the courts, with STIMA, you can actually go and take the asset or demobilize it. Of course, in a particular situation, you could ask the police to assist you. Again, this is another sensitive part of the Act. And I recall the judges were uncomfortable with this. This particular provision only comes in if the borrower has signed an agreement giving the creditor or the financial institution the right to sell the property or the right to use the police without reference to the courts. So it's a pre-existing right that has been offered and accepted by the creditor, and it was based on that. It was a condition precedent to the credit being offered. So I don't think there's anything to worry about. And this is common in the entire world. Of course, some will ask that in Nigeria the police might be mischievous. That may be so. What the Act provides is that the police is there to maintain peace. So where there's resistance, the creditor might still end up in courts. But you have to understand that the nature of the assets we're talking about can easily be dissipated. So you need that extra additional enforcement procedure. The one other procedure that you'll find in STIMA, National Collateral Registry, is that the creditor and the grantor, in other words, the grantor of the security, both must sign an agreement that if there's any dispute, it must first be referred to arbitration before it gets to the courts. So what the courts would ordinarily be faced with is whether or not the arbitration had been conducted in accordance with the principle of law. In other words, the courts should discourage anyone coming there for the first time. You must have exhausted the procedure that has been created before you come there. This is an important procedure in the collateral registry structure that you don't have in CAMA. When a debenture is taking over an asset, it can only be taking over an asset that belongs to a company. You can't take a debenture over an asset that belongs to an individual. That's another important distinction. Land cannot be the subject of registration under the collateral registry, but it can be the subject of registration under CAMA pursuant to a debenture having been taken. Normally what will happen is that the mortgage taking over the land will be registered at the land registry. the debenture taking over all the assets, including the land, will be registered at the company's house. Finally, and I think this is important, what is the relationship and the interface between the registry, the company's house, and the registry, the collateral registry? The collateral registry, the act that creates it, provides that it should interface with any other registry where assets are being secured. That has not been achieved yet, but it will be achieved soon. So what it will mean is that you could simply do a search in any of the registries and it will show that certain assets are subject to collateral. But today that is not the case. And so of course the next question that will be asked, when you register assets at the Corporate Affairs Commission, and then such asset is also registered at the collateral registry, which one takes priority when there's a default? It is difficult to answer that question without actually being presented with a particular facts. In other words, it is fact sensitive. But let me give a general proposition. The nature of the charge that is taken pursuant to interest being registered at the company's house is a floating charge. In other words, it's not crystallized. Whereas the nature of the interest that is taken at the collateral registry is specific. It's almost like a fixed charge. And naturally, a fixed charge will take priority over a floating charge. But those are very general statements, because in the collateral registry, you could also have a charge over future properties where it is not specifically identified. Under that situation, my proposition or my contention is that you would have to look at the entirety of what is presented to you and the common law principles of priority to determine which one takes priority. Let me end like this, my lords. This particular act is an innovation, and this act is to stimulate lending to those who deserve lending but who cannot get it today. It will revolutionize our credit system, and it will assist those who are at the bottom of the ladder. My contention is that when these matters come to the courts, they should be interpreted in accordance with the objective of the act. I would give an analogy of what I consider to be an interpretation which perhaps failed the objectives of the Land Use Act. The well-known case of Savannah Bank and Agilo is a typical case, in my view, that restricted lending where land is provided as a collateral. The facts of Savannah Bank are typical. Agilo had sought for credit from Savannah Bank. He was offered the credit and he offered a mortgage in return as collateral. Of course, he failed to pay his debts, and the bank sought to realize the collateral. Both Savannah Bank and the borrower had executed the collateral agreement. But as is well known, the provision in the Land Use Act provides that the governor must first give his consent. Both were laboring under the erroneous impression that they had a legal mortgage, but unfortunately the governor had not given his consent. When the bank tried to realize, Mr. Agilo raised the defense that the governor had not given his consent. Consent had not been first had and obtained. Those are the words. The matter traveled all the way to the Supreme Court, and the Supreme Court held, rightly perhaps, that the governor's consent ought to have been obtained. That was fine. But the consequence of the failure of obtaining it was where perhaps I think the Supreme Court got it wrong. The Supreme Court held that the transaction was void as opposed to voidable. What that meant was that the bank was not able to obtain his credit, neither could they realize the asset that was offered as security. If it was held to be voidable, it will simply mean that the governor's consent, once obtained, they could realize the security. Of course, subsequently, in a way, Jugbagbe Light Industry and National Bank it's been held that it's avoidable. But that took 10 to 15 years. But the consequence of that decision meant that the banks froze and failed to give credit once land was offered. Because we must realize that the monies that the bank give out don't belong to the bank, they belong to depositors like you and I. What that effectively did was to shrink the residential mortgage market. So today you have less than 0.5% of residential mortgages offered. My admonition is that when interpreting these acts, we don't get to the point where the decisions that have been delivered or that will be delivered will stifle credit to those who deserve it in Nigeria. Thank you very much, my lord. Thank you.